This episode contains references to sexual abuse and exploitation. Listeners' discretion is advised. Earlier this month, an investigative report by the BBC exposed how Instagram's recommendation systems were used to push child sexual abuse material or CSAM-related ads to Indian users, escalating from adult content to explicit material within days, without the user even searching for it. The findings triggered government scrutiny of Meta and renewed questions about the role of social messaging service Telegram, where the content was being traded. But this isn't just a story about one platform or one investigative report. It's a story about what happens when recommendation algorithms learn and predict faster than the law can respond. It's about whether the dark spaces of social media you're often pushed into happens by accident or laxity or intent. In fact, where does intent sit when a machine, not a person, makes the push? Can an intermediary claim safe harbor for what its own system is designed to amplify? And as harm gets distributed or diffused across ad networks, messaging apps, and payment systems, who actually holds the liability? The platform, the officers behind the design, the sellers and the buyers, or all of them? To dig into these questions, I speak to Supreme Court lawyer Sajan Poovayya on intent, platform liability, and how India's law is evolving to catch up with the technology it's meant to govern. It's Tuesday, the 14th of July. I'm Anirban Chowdhury. This is the Morning Brief. Hi Sajan, very warm welcome to the Morning Brief.
Thank you.
So this conversation is based on the recent BBC investigative report on child sexual abuse material, or CSAM, on Instagram, which was available on Instagram and then traded on Telegram. So I'm kind of trying to take the conversation forward with questions around intent, algorithm, harm, and how liability can be attributed to an intermediary also. Now, one of the striking findings of the BBC report is that the CSAM content material can be algorithmically pushed towards a user even if they don't search for anything similar. So my question to you is, does the law have any way to assign intent to the platform itself when something like this happens?
See, Anirban, we should be clear that when we speak of CSAM, that is child sexual abuse material, and any other material which possibly may be illegal, we should really be looking at it on two different pedestals. CSAM has reached a level of legal maturity across jurisdictions that it's almost strict liability. If you're in possession of child sexual exploitative material or abusive material. And therefore, if that's the level of legal liability that is being cast, everyone, whether it is individuals or intermediaries, have to tread that path very carefully. Criminal law in India would not really hold the algorithm itself to hold criminal intent or liability, because that doesn't happen, because algorithms have no legal personality. So therefore, the real question will be whether corporations acting through its officers, product designers, product design decision makers, etc., can be said to possess the required mens rea. Now, that's a deep question. Therefore, whether we look at the Bharatiya Nyaya Sanhita or whether look at POCSO as a legislation in this country, that's the legislation to prevent sexual abuse of children, or the Information Technology Act itself, intention and knowledge can be attributed to a company through its directing minds. Therefore, if there is evidence to suggest that an intermediary or its officers knew that its recommendation system repeatedly surfaced CSAM, or if there were internal reports which documented the issue that CSAM is repeatedly being surfaced, or if there is a better, safer product design or alternative available, but the intermediary did not adopt that alternative design, because it wanted to still have an engagement maximization architecture for its product in terms of pushing material to you, then the legal issue shifts from accidental publication to knowingly facilitating through product design a push of information. Now, there I think the balance changes. An accidental publication of CSAM material, an intermediary still has safe harbor. If it is brought to its notice, it will immediately put in place technological measures, not just to purge that content, but even under the extant regulations in India, which is the Digital Ethics Code of 2021, a significant social media intermediary is obligated to endeavor and deploy technological measures to delete all such information available. It is also mandated to have technological measures which will prompt and put up a pop-up message when somebody searches for CSAM material or child sexual abuse material, rape videos, etc. So therefore, the key issue then is it accidental, or is it a scenario where architecturally an engagement maximizing architecture pushes such material to a consumer?
Understood. And that's very well put, Sajan. Do we have any precedents where it was architecturally pushed, like you said, instead of being accidental?
Answer is no, but I think slowly moving towards that regime, because if you look at even the Supreme Court of India in that Just Rights for Children Alliance matter, the Supreme Court recognized the fact that every viewing and circulation of CSAM perpetuates abuse and re-victimizes the child, and that's the statement that the court made, and therefore the court said that a Section 79 safe harbor may not be available if there is an aiding or abetting or inducing by the intermediary. Now, it also indicated that there will be something called constructive possession, which will be brought in when it comes to CSAM material. That is, it is available on the intermediary's platform, but the intermediary does not directly or know that it is available, or it is not the intermediary which has brought such material in. Akin to, for example, if it is available on an individual's phone, the individual might say, listen, I did not know. And therefore, the court explored the possibility of constructive possession, like for narcotics and psychotropic substances, constructive possession of a drug. And Supreme Court said that for establishing constructive possession, let us say even of CSAM material, you need two tests. One, you need to have the power to control the material in question. Second, you need to have the knowledge that you can exercise such control. For example, it is sitting in my inbox. I know that I can delete it, right? But I still don't delete it, which means I know I have control over that material, but I use that control to purge the material. Then possibly I am deemed to constructively possess such material. The minute constructive possession comes in, then you get into the situation of traditional law coming in to say that, all right, you are in possession of a particular material. Section 15 of POCSO then comes into the scenario. It's a criminal offense under Section 15 of POCSO. Supreme Court recognized such situation even in Prajwala versus Union of India, the 2026 judgment. Therefore, the question is, if you look at a precedent where an intermediary has been held liable for such algorithmic practices, answer is no. But are we slowly moving towards that genre? Answer, I think, is yes. First few steps, baby steps, but I think we will be there soon.
Got it. Got it. Now, let's look at it from the corporates or the companies or, well, the intermediaries' point of view, and what they usually sort of present as a reason or excuse or shield, whatever you may call it. For example, companies such as Meta call this whole problem a constant battle against bad actors that are hiding amongst billions of users. Now, is that a legitimate defense in law, or are these companies just hiding behind an engineering problem?
A couple of quick observations on it. You see, I'm a tech lawyer, and therefore, the bottom line should be that our starting point can't be that we use law against technology, and that really shouldn't be the point. There should be a fair assessment of how things work. Number one, look at it from 3 or 4 perspectives. First, when it comes to child abuse material, first, society has an obligation to ensure that the child is protected. Our constitution under Article 15, subclause 3, 21, 21A, 39 subclause E, 39 subclause F, 47. I can just go on with multiple articles. All of it communally, there is a scenario where the Constitution collectively strengthens a constitutional obligation towards such protection. And please look at it, the child can't protect itself. Therefore, we as a society, we hold that child in trust. Therefore, we need to exercise every power that we have to make sure that the child gets a safe environment to blossom, bloom, and grow up. Now, in such a situation, can it be said that a recommendation system which is put in place by an intermediary can then be brought in as a scenario to say, sorry, the defense is that I have billions of people. In my view, the answer is, and a rational answer to that question is the following. One, you should first see whether the recommendation system, which is employed by the intermediary, predictably pushes CSAM material or CSAM to a user, number one. If it predictably pushes child sexual abuse material to a user, the harm occurs the moment the recommendation is made and the dissemination is made. Therefore, there is automatically a legal obligation to ensure that this is brought to check. Now, let's come to scale. Anirban, tech is not the only industry which deals with scale. And tech is not the only regulated industry that deals with scale. Every regulated industry faces scale. Banks, for example, process billions of transactions. Stock exchanges execute millions of trades in a day. Telecom companies carry billions of calls. Scale, in my view, never eliminates the obligation to exercise reasonable care. It cannot. Scale can never be used as a defense to say, I cannot exercise reasonable care. Reasonable care has to be exercised. Billions of users upload content, and that is only the beginning of a legal inquiry. The real question will be whether the systems are reasonably designed such that this care will be taken, such that where there is a foreseeable risk, the risk can be mitigated. And when something of this nature pops up, what is the due diligence that has been exercised to correct and purge such material? But even under the extant rules of 2021, as I said, whether you look at Rule 3, whether you look at Rule 4, there is an obligation that an intermediary will not have child sexual abuse material. It will actually confirm that it will impose the obligation on all its users not to have CSAM, and it will put in place, if it is a significant social media intermediary, Meta is, that it will put in place a technological platform in all its technological endeavors. If a technological solution is not available, you can't ask an intermediary to create one. But if a solution is available, it has to be put in place to ensure that despite billions of users, despite this constant battle against bad actors, you have a reasonable system which will prevent dissemination of CSAM. That's the answer.
Got it. But my question also is, does it have to be as serious an offense as CSAM content distribution for these things to come to light, and for these organizations that we are talking about not to use shields of automation and human agency, etc.?
No, I understand. And again, let's be fair to these organizations and the technology that they operate in as well. You see, I don't think, at least to my knowledge, we really don't have a foolproof tool which will predict what will be put up by the user and kind of check it before it is actually hosted. And therefore, gatekeeping obligation, I don't think can be put up on intermediaries as yet under the extant technology. Therefore, the law has been very careful about it. If you look at the 2021 rules, the Digital Media Ethics Code, etc., that really calls out these two categories. It does not call out all categories. It says that a significant social media intermediary shall endeavor, again, it's an endeavor scenario, to deploy technology-based measures, including automated tools, to do what? To proactively identify any act of simulation of rape or child sexual abusive conduct. Those are the two categories. It does not put the same obligation for, let us say, communally sensitive material or breach of privacy. Such obligations are still not extant in the law, and rightly so, because we are in an evolving technological paradigm. And therefore, to impose a legal obligation necessarily means that you are clear that there are instruments available to comply with the law. I can't really push a person to comply with the law and do the impossible if the technological scenarios don't permit it. But when it comes to child sexual abusive material or rape, etc., the law imposes a higher threshold of obligation. And that's why I keep these two in a different category.
Understood. And Sajan, my final question, since we are talking about how the law and guidelines are evolving, is if the harm is diffused across various stakeholders like ad systems, payment rails, messaging apps, does the current framework of rules allow for shared liability, or are we getting to a place where it will?
Answer is, I think we have a hybrid. Please look at it this way. And for a minute, permit me to take you back, because you're right. These questions are, very intertwined, and they will be, because the technology that we are dealing with is itself very intertwined. So, you see, the law looked at a scenario where it brought in a set of postulates to follow on the basis that there will be three separate scenarios. That is, there will be a user. The user will actually punch in the searches, and the platform simply will return a result. Therefore, a platform was passive in a safe harbor. It is the user who pulled material towards herself or himself. That is a user indicating a church. But please now turn up and see what's happened. Today, we have a stage where, although the law predicated itself on a user searching and a platform returning result independently,
Right.
today, given AI and the AI algorithms that are available, today a platform analyzes user behavior. It predicts user engagement. It selects content which the user may want to see. It tests the response of the user to such content. It learns from that response and whether Sajan likes a particular content or not. And once it has learned, it serves Sajan even more of such personalized content. Therefore, this whole passive scenario of an intermediary is changing, and there's nothing legally wrong about it.
Got it.
Therefore, when this changes, the issue of attributing legal liability also must be looked at from a perspective of saying that liability will be dependent on your control. Greater the platform's control over what the users actually see, the weaker becomes the argument that this is the user's free choice. Now, in that light, if you tell me that can you actually diffuse it across systems, etc., answer is please look at how the internet functions today. Internet functions through an interconnected ecosystem, as we all know. Now, where each participant performs a legally distinct role, that is, there is an uploader, there is a hosting intermediary, there is a recommendation platform which has recommendatory algorithms, there is an advertiser who's advertising, there is a payment processor who's collecting your payment, there is a cloud provider who's hosting that material, there is a messaging service which is connecting all of these people. But Indian law already recognizes conspiracy, common intention, abatement, aiding, facilitation, independent statutory obligations being brought together for collective criminal liability. All of that is recognized in the traditional notions. Therefore, answer is, I think, as we develop, we need to have a greater degree of control in terms of rational regulations being brought in, compliable regulations being brought in. And I'll leave you with one example. All of us get so bogged into tech and tech regulation over the last few years. Under the Consumer Protection Act, the Central Consumer Protection Authority brought in something called the Guidelines for Prevention and Regulation of Dark Patterns.
Yeah, of course.
Now, what are these dark patterns? For example, now look at it from a non-CSAM perspective, indicating a false urgency for a consumer. Click now, otherwise you will lose it. We have only 2 left in the basket. Basket snatching. You put something into the basket, they snatch and put something else in it. Or confirm shaving. If you don't confirm to this, or you have not taken it with an added insurance, that means you are at risk. If you add insurance to your travel, you are not at risk. Therefore, conform to the mandate. Otherwise, I'm shaming you, saying now you're putting yourself in risk. Or forcing somebody to take action. Or putting somebody in a subscription trap. You have subscribed for 1 month, it will continue now month on month. And I'll make it difficult for you to get out. Now, this bait and switch scenario, saying that I'm showing you something for you to bait and say I'll buy, but by the time I buy, I'm switching it to a lower product. Now, all of this were looked at as dark patterns, and the Consumer Protection Authority brought in these guidelines. And these are not simple guidelines simply on the book. That Physics Wala Limited, there was a penalty imposed. McAfee Software penalty was imposed. So, though certain entities have been penalized for dark patterns.
Right.
Why can't we apply the same yardstick for intermediaries also when it comes to certain content? CSAM, for example. If there are certain mandated thresholds which are expected of an intermediary and the intermediary has met those thresholds within the technological constraints, then there is no liability. If the intermediary has not met those thresholds within the extant technological constraints, then there will be liability, because similar to dark patterns, you bring in some sort of a regulation here. So I think regulators also have to think proactively. They have to think practically. They have to think within the constraints of extant technology and not expect intermediaries to do beyond what technology enables them to do, but certainly do as much and as necessary within the extant technology to ensure that CSAM material is not disseminated.
Okay, but I have a counterpoint to your example regarding dark patterns. The measures that you're talking about have not been extremely impactful, right? Like, I still get prompts on my phone whenever I'm booking a flight ticket on whether I want to travel unsecured or uninsured. Some websites still have, slightly darker colored patches for options that they would want me to choose. And then some websites still have that one seat, one room left thingy. Would you agree that impact on all of these tech platforms would be limited because everything is so spread out and so seemingly organic and most importantly evolving so fast?
So fast is again not an answer. Again, as a tech lawyer, I think the speed, scale, etc. should not be a defense either for the intermediary not to comply or for the regulator not to apply its regulation. I don't think speed and scale should become a defense for either of the parties. If you require a thriving technological ecosystem, but appropriately governed and effectively implemented, then our regulators must learn how to implement. You are right that the Central Consumer Protection Authority's dark pattern guidelines, according to me, are very well drafted. Has it had the impact that is expected in a country? Now, that answer is not because the law is not well drafted. Now, if the implementing agencies don't implement it with full force, then you know what happens. It's like saying that I will not catch hold of the first cycle thief until I can catch hold of all cycle thieves. And you can't do that. You need to catch hold of who you can get and make an example of them so that people learn from these examples to ensure that structurally and from a ecosystem and in commerce, they don't undertake such patterns. I always believe that when it comes to tech and tech regulation, the first key is to make sure that you draft rational regulations. You promulgate those regulations which are implementable, which are rational, which are in tune not just with the extant constitutional legal regime, but is also in tune with the extant technologies. Second, you need to have a methodology by which you need to implement it. Light touch, I have always said that in tech, light touch approach is what the regulators must follow. Regulators must first bring in regulations which are clear and educate the intermediaries to say these are the regulations, operate within it. I would think most intermediaries, they are global players, they are mature players, they will operate within that system. The trouble arises when the person implementing these regulations expects more than what the technology permits the intermediary to do. Please make sure that you have cleaned material even before the material is hosted on your platform. No, these are impossibilities. But to tell a regulator that this is impossible will take another task. And therefore, I think that dichotomy continues, not just in tech regulation, in many other fields of regulation in this country.
Understood. And on that note, thank you so much, Sajan, for joining us. Great insights. Thank you.
Thank you. Thank you.
So, as India's platforms face mounting scrutiny, this investigation is again a reminder that harm most often moves through the most legit digital channels: social media, messaging, payments. Each link in the chain shirks responsibility. The abuse continues. What will it take to break this chain? We leave you with this question. That's it for today. You were listening to this episode of The Morning Brief. It was produced by me, sound designed by Indranil Bhattacharjee. Keep listening to our podcasts on your favorite audio platforms. Stay tuned.